Hello, 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 everybody, and welcome. We are just getting set up here, so let everybody get in. I'm just waiting for everybody to get in. If you can smash that like button on your way in so people know that we're going live. This has just come out. It was just released. There she is, a cat. So we're going to give it a few minutes and let everybody get in that wants to see this. Thank you, everybody, for smashing that like button. That way we can get going on this. So this is the information that we've been waiting for, you guys. I haven't even read it myself. Hello, Lorna, Nana, Alicia, the Real Angel, Sarah, Emily. Hello, everybody, again today, for those who were here with me this morning, too. Jeannie, hello, Emily, Marie, Lion and Lamb, the Real Angel. Please smash that like button, everybody, on your way in. Let everybody know that we are live so we can get going on this, so I don't have to keep stopping and repeating. We've got the new documents that the judge just released in the Lori, Vallow and Chad Daybell matter. We've been waiting for this to see what's going to happen. Like I said, I have not read through the documents yet. So please give that video a like so we can get going. Lets everybody know that we are live. Hello, hello, everybody. Hello, plucky little poppet. Thank you for popping in. Okay, you guys, we're going to get started. I'm going to ask while we're reading through these documents, please don't comment anything that you've seen on other channels, other platforms, other creators. We don't do that here. I don't think anybody has covered this yet. It's just come out. So let me get going with this. Let me get my screen shared for you guys so you can see this all. Like I said, I have not even read this myself yet. I wanted to go through it with you guys. Hello, everybody. Glavana, thank you for smashing that like button, you guys, on your way in. Thank you, thank you. I appreciate it. So like I said, I haven't even read this yet, so I don't know what the decision is. We're going to go through this together. Please, if you have heard anything about it, please just let us get through this and don't spoil it for everybody. Okay, so as you know, last week, Lori did not waive her right to a speedy trial, so her trial is set for October 11th. Chad's is set for January 9th, and the state had filed a motion to keep them joined and have Lori's trial moved to January, which would breach her constitutional rights to a speedy trial. The speedy trial has to be done within 6 months of time of arraignment. So that would bring them to October. They had to have it. Now, also, I want to let you guys know, I made comments about this morning that I believe the judge had one of two choices that he could make: either try them separate or move Chad's up to October. So that way they are not breaking Lori's constitutional rights to a fair trial, because I believe on appeal, she could walk. Okay? And that's a very, very real possibility. So I want you guys to keep that in mind. Those were the choices that he had to make. Okay, so let's get going, you guys, on this. So this is the judge's decision. When we left the hearing the last time, he said that he would take this on advisement. So here it is. The state filed its motion to find good cause to continue the trial and prevent improper severance on May 2nd, 2022. The defendant, Lori Noreen Vallow Daybell's case, requested in court to find good cause to continue the defendant's currently scheduled October 2022 jury trial. The defendant filed a response to the state's motion, having fully considered the parties' briefing and oral arguments presented in a hearing on May 19, 2022. The court issues as follows. So remember, at that May 19th, which was last week, court hearing, Lori still refused to waive her right to a speedy trial. Okay? Let me just see here. Hang on a sec, you guys. Okay, so procedural background. On May 25th, 2021, a Fremont County grand jury returned an indictment charging defendant Lori Vallow and a co-conspirator with Chad Daybell in the commission of several crimes, including 2 counts of first-degree murder. Before defendant could be arraigned in district court pursuant to Idaho Code 18212, the court found defendant was legally incompetent to stand trial and ordered her commitment to DHW for care and restorative treatment. Accordingly, on June 9, 2021, the court entered an order staying her case pending her commitment for restoration treatment. On April 11, 2022, the defendant was found competent and fit to proceed to trial. This court lifted the stay in her case and ordered her to appear for arraignment on April 19th. Okay, so that was just a while ago, last month. She was finally arraigned. So from April, they have 6 months to get her to trial because she's still, even in her court case last week, she refused to waive her right to a speedy trial. She wants her trial. She wants it within the speedy trial rules, which brings it to October. Okay, so the last hearing, like I said last week, she still has not waived her right, and she still to this day has not waived her right to a speedy trial, which means they have to have her in court within 6 months. Otherwise, they breach her constitutional rights and she could walk on appeal. Okay, so this court lifted the stay of her case, ordered her to appear for arraignment on April 19th, 2022. During the arraignment, the court advised defendant of her rights and subsequently scheduled her trial for October 11th, 2022. On May 2nd, 2022, the state filed a motion requesting the court to continue the defendant's trial to January 9th to coincide with the setting in alleged co-conspirator Daybell's jury trial, and in order to avoid an improper severance of the co-conspirators' cases. On May 12, 2022, the defendant filed a response to the state's motion stating she did not waive her right to a speedy trial. Okay? And that she understood the continuance would provide her defense team extra time to prepare her defense. On May 19, 2022, the court heard the parties in oral argument. Criminal defendants are guaranteed, here we go. Let's read this. Okay? Criminal defendants are guaranteed the right to a speedy trial, public trial, under the 6th Amendment to the United States Constitution and under Article 1, Section 13 of the Idaho Constitution. In Idaho, these constitutional provisions have been supplemented by legislation that sets specific time limits within a criminal defendant must be brought to trial. Indeed, the operative statute was enacted in 1864, where Idaho was still a territory and was still in force and effect at the time of the adoption of our Constitution. The current vision of Idaho Code Section 193501 states, the court, unless good cause to the contrary is shown, must order the prosecution or indictment to be dismissed in the following cases. When a person has been held to answer for a public offense, if an indictment or information is not found against him and filed within the court within 6 months from the date of his arrest, if the defendant whose trial has not been postponed upon his application is not brought to trial within 6 months from the date of the indictment or information is filed in the court, and if the defendant charged with a misdemeanor offense whose trial has not been postponed upon his application is not brought to trial. So these are good cause to the contrary must be shown or the indictment to be dismissed, okay? Within 6 months from the date the defendant enters a plea of not guilty with the court. Thus, under Section 193501, criminal defendants are given additional protection beyond what is required by the United States and Idaho constitutions. The statute mandates that unless a state can demonstrate good cause for a delay greater than 6 months, the court must dismiss the case. And I don't find they have found good cause. She has a right to a speedy trial. Thus, the defendant is afforded both constitution and statutory protections as they relate to her right to a speedy trial in this case. An inquiry into a speedy trial claim necessitates a functional analysis of the right in the particular context of the case, as Justice Powell, writing for the court in Barker versus Wingo, explained. The right of a speedy trial is necessarily relative. It is consistent with delays and upon circumstances. It secures the rights to a defendant. It does not preclude the rights of public justice. A fact-specific inquiry is necessary to assess the particular context for any case where a delay has or is anticipated to frustrate an individual's right to a speedy trial in order to determine whether good cause exists. Whether there was an infringement of Clark's statutory right to a speedy trial presents a mixed question of law and fact. The court will defer to the lower court's findings of fact if supported by substantial and complex evidence. Okay? Good cause means that there is substantial reason that rises to the level of a legal excuse for the delay. Because there is not a fixed rule for determining good cause for the delay of a trial, the matter is initially left at the discretion of the trial court. Where there is good cause for the failure to try the accused within the applicable statutory period, the delay is generally not violative of the accused speedy trial rights. Finally, the state bears the burden to demonstrate good cause for a failure to bring the defendant to trial within the 6-month limit. Now, the reasons they stated is that they're both charged with the exact same offenses, that the prosecution is going to use the exact same evidence against both, and I'm going to give it to you. These are their reasons. They committed the crimes together. The prosecution will be using the exact same information against the two of them, and that they still haven't got some of their DNA evidence back, blah, 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 blah. Well, that's not the defendant's fault, and it cannot be held against the defendant to waive her right to a speedy trial. They've had 2 years to get their crap together. If they have not been able to do that in 2 years, then they can not use that against the defendant to extend the speedy trial. Okay? Neither is it that they would have to try the exact same case twice and use the exact same information twice. That's not the defendant's fault, okay, and cannot be used against them. And I believe the reason why the prosecutions want this case tried together, they don't want to have to try the same evidence twice, and cost factor, which none of that you can use against the defendant to revoke their right to a speedy trial. Okay, so with them asking this, I don't know what the judge has done yet, but if they've asked yet, we'll get to it. For that cause, they don't have justification. Okay, in my opinion, Lori is still entitled to have her case unless she's waived her right to a speedy trial within 6 months. Okay? Analysts. The state has argued that good cause exists in this case to extend the statutory 6-month limitation for the defendant's trial, urging the court to schedule a trial concurrently with the Daybell trial in January 2023. The court must ascertain whether doing so is justified by good cause and would not deprive the defendant of her constitution and statutory speedy trial rights. So she's not just covered by her constitutional rights. There's also statutes in her state, which also gives further rights. Okay. Thus, the court considers the mixed question of the fact and law in determining whether the state has demonstrated any substantial and competent evidence that the delay here is warranted. The grand jury issued their indictment in this case on May 24, 2021, and it was filed on May 25, 2021, charging the defendant with the commission of several crimes. Thus, the indictment was timely filed pursuant to the sections. Thereafter, there was a substantial delay in bringing the defendant to appear for arraignment due to the state in the case. The court therefore considers whether that delay violated this section here, which requires trial within 6 months from the date the information is filed. No, it requires the court to bring her to trial within 6 months of arraignment, not from this is wrong, not from the date the information is filed. She is entitled to a speedy trial within 6 months of arraignment. If the trial had not been postponed by application of the defendant, Idaho Code, and they're playing with words here because it says, which requires trial within 6 months from the date the information is filed. That is wrong. The court has to get her to trial within 6 months that she is arraigned. So, and why I'm saying this, you guys, the information could be filed and a warrant put out for somebody's arrest. If it takes them 8 months to arrest them and arraign them, they have a right to a speedy trial from the date of their arraignment, not from when the information was filed. So they messed up there as far as I'm concerned. We'll see what comes out about that at a later date, but I believe that this is wrong. They require the speedy trial has to happen within 6 months of date of arraignment, not from when the information was filed. Idaho Code creates an exception when a defendant's trial is postponed by their own application. Defendant's attorney of record filed a request for this court to order the defendant to undergo a mental health evaluation in a related case prior to filing of the indictment in the instant case. So she was already being sent for a mental health evaluation regarding the charges that were brought against her with not producing the kids. That's before the filing of this indictment with the court for all the murders. Okay? So that is a problem for the court because she's already being sent for an evaluation. You cannot arraign her when she is incompetent. You have to wait until she's brought back to competency. So she has a right to a speedy trial from the date of arraignment, not from the date that this was filed with the court. On June 9, 2021, following an evaluation and the report on the defendant's mental health status, the court ordered a finding in the case that the defendant was incompetent to stand trial and ordered her committed to the Idaho Department of Health and Welfare. So she had not been arraigned yet. It starts from date of arraignment, which was last month. Accordingly, the court entered a stay halting the proceedings in her case pursuant to the Idaho Code section 18-212. Now, the judge is the one that entered the finding in the case that the defendant was incompetent because of her being sent for a mental evaluation in the prior case. This had nothing to do with Lori Vallow as per se. They didn't ask for this case to be put on hold and her not be brought. She couldn't be. So them saying that it's because the defendant did this in this case, they're wrong. That was done in a separate case. The two cases are separate. The one for not producing the kids is separate from this case. They're two different court files and two different sets of charges. They're not together. They haven't been joined together. Okay? So because she was found incompetent to stand on the prior charges, they couldn't enter these charges against her until she was brought and arraign her until she was brought back to competency. So it's not the defense's fault. The court determines that the due and required stay of the case, there is substantial and competent evidence to that exception that applies, this section here, as the delay before arraignment was through no action of the court or the state, rather a direct consequence of the determination that the defendant was not fit to proceed to trial. Well, you cannot blame a defendant for being incompetent. And that incompetency was in another court case, not this court case. And she was found to be incompetent and sent off to the mental hospital before they could file and arraign these charges on her. So it's not, you cannot blame a defendant for having a mental health. That's why a lot of people get off on not guilty by reason of insanity, because you cannot blame a defendant for their mental illness. This is whacked out. Anyway, thus, and this is why I think if they're going to move her trial to January, which it's sounding to me like that, I haven't read it yet, but it sounds like that's what they're going to do. Lori could walk. I'm telling you that right now. Lori will walk on appeal. Thus, the period of time Vallow spent committed to the custody of the Department of Health and Welfare is told for the purpose of calculating speedy trial timing as it relates to her arraignment date. No, they can't do that. She's going to walk if they do this. And I'm looking, you guys, like they're going to put her trial over to January by the sounds of this so far. On April 11, 2022, the defendant was found competent and fit to proceed to trial and was thereafter arraigned on April 19th. That's when the 6 months starts for her speedy trial. That implicates the timing in IC 1935-013, which requires trial within 6 months of arraignment. There you go, which is October 19th. They have to start the trial by October 19th, 2022. The state argues good cause exists to extend the defendant's trial to coincide with the date set in the Daybell case beginning January 9th, 2023. The defendant has not waived any speedy trial right. And don't forget, she's protected under the Constitution and she's protected under state statutes, which gives her a double protection to the right to a speedy trial. Now, they just sent it right here. Thereafter, arraigned on April 19th, that implicates the timing, which requires trial within 6 months of arraignment. So what they're saying up here, I have no idea. Accordingly, the court will apply the Barker-Wingo factors to determine whether there is good cause to delay the defendant's trial. In the Wingo test, analyze the speedy trial claim pursuant to 4 factors: the length of the delay, the reason for the delay, the defendant's assertion of his right, and the prejudice to the defendant. The Idaho Supreme Court has determined that the court should consider the Barker factors, but look beyond those factors in determining if good, but look beyond those factors if good cause under 3501 exists, okay? There is none. The only reasons they've given is it's going to cost them double, and they're going to have to try it twice with the same evidence, and that they don't have DNA back yet. None of that is the fault of the defendant. That's on them. Upon careful consideration of the relevant authorities, we believe that a thorough analysis of the reasons for the delay represents the soundest method for determining what constitutes good cause. We therefore conclude that good cause means that there is a substantial reason that arises to the level of a legal excuse for the delay. Oh my God. Length of delay. You guys can pause this later if you want. They're just going through other court cases. Here, the length of the delay, should the court move the trial from October to January, is a period of 90 days from the current trial setting. This is all their argument that they argued. For the purpose of evaluating the defendant's statutory right to a speedy trial, it's 82 days beyond the deadline. Thus, the length of the delay here serves as the triggering mechanism for further analysis. The length of the delay here is 82 days, and in consideration of the complexity of this case and the seriousness of the charges the defendant faces, as more fully explained herein, the court determines that the length of the delay here weighs in favor of granting the state's motion. Oh my God. Okay, so here's the reason for delay. Our speedy trial standards recognize that pretrial delay is often both inevitable and wholly justifiable for the reasons such parties need more time to collect witnesses or oppose pretrial motions. A deliberate attempt to delay the trial in order to hamper the defense should be weighed heavily against the state, which they didn't do. They're more concerned about having to spend the money on 2 trials, having to try the trial twice, and not having their crap together yet. This is why Barry Morpheus was dismissed without prejudice, because they didn't have all their shit together yet. And neither does this case. They've had 2 years to get it together. That should not revoke Lori's right to a speedy trial, because the state doesn't have their crap together. The defense has said they're ready to go, and she will not waive her right to a speedy trial. A more neutral reason, such as negligence or overcrowded courts, is weighed less heavily, but nonetheless slants against the state, since the ultimate responsibility for 584 or 1200, which circumstances must rest with the state rather than the defendant. The state cites multiple reasons for the delay. The stay in this case occurred when the defense counsel raised concern that the defendant may be incompetent to stand trial. Well, that's not her fault. That was decided before this was even filed with the court, these new charges. The resulting extended period of time during the restorative treatment while committed cannot be overlooked, as assessing the delay from the beginning date of indictment was filed to the present. Yes, it was filed, but she wasn't arraigned. And she was already being sent off to the mental hospital on other charges before the indictment was even filed. So they can't ding her for that, and they are. As competency was established and the case came before the court for arraignment, the delay between arraignment and the trial date becomes the focus. The period of time the court must scrutinize is the time period between October 19th and January 9th. To ascertain whether there is good cause to continue. The primary rationale argued by the state to move the defendant's trial beyond 6 months is to prevent an improper severance. Defendant and Daybell were named together in a single charging document, the indictment. This court has ruled that they are and continue to be properly joined for trial. A motion to sever filed in Daybell's case was denied. The defendant's defense team was only recently fully assembled under the Idaho Rule 44, and her counsel has indicated they need time to prepare a full defense on her behalf. But they said that they wouldn't oppose the extra time if the court decides to move it. But in the same breath, her lawyer said, but she is not waiving her right to a speedy trial. She wants to go ahead in October, and they would be ready to go ahead in October. Although they'd have to work day and night, they would be ready. So they're using this wrong. Lori's going to walk on appeal, I guarantee you. The indictment charges defendant and Daybell with the most serious crimes. They are alleged to have co-conspired to commit murder, and the state has filed its notice of intent to seek a death penalty in both cases. In addition, there are allegations of conspiracy to commit multiple financial crimes. These conspiracy allegations were the basis of the court's decision to deny Daybell motion for severance. The court has been advised throughout the proceedings by counsel for both defendants that an extraordinary volume of discovery has been produced. Defendants' attorneys have expressed their concern in regards to having adequate time to prepare for the trial in October, although they have in no way argued against their client's assertion of her speedy right. Exactly. They said that they would make sure that they were ready to go. So don't use that as an excuse to put her trial off. For reasons more fully set forth in the court's March 21, 2022 memorandum decision denying the defense motion for severance filed in Daybell case, the court concluded that the two defendants will be tried together. The state's argument that an improper severance may occur if the defendant's trial proceeds in October is well-founded. In order to preserve a single trial, the court will be required to advance Daybell's trial. In order to preserve a single trial, the court would be required to advance Daybell's trial to October. This could potentially deprive Daybell of necessity time to prepare for trial, wherein the court has previously scheduled his trial for January, and his attorneys have reasonably relied on that setting in his ongoing preparation. Given the directive that the court consider whether there is substantial and competent evidence rising to the level of legal excuse for the delay, all of these factors weigh in favor here of such finding when considering the reason for the delay. Defendant has unequivocally asserted her right to a speedy trial. That's right. Prejudice to the defendant. Prejudice to the accused caused by trial delay is assessed in light of the interests of the defendant. Those interests include 1, to prevent oppressive pretrial incarceration, 2, to minimize anxiety and concern of the accused. Right, because she's teetering right now on being incompetent again. You don't want to do anything to her that's going to send her over the edge again, and she ends up back in the mental institution. And by moving her trial, and denying her right to a speedy trial could just do that. So to minimize the anxiety, and that's why you get a speedy trial, okay? It's to prevent oppressive pretrial incarceration, to minimize anxiety and concern of the accused. That should be foremost with Lori Vallow, because she's teetering on the edge of being incompetent again. And to limit the possibility that the defense will be impaired, infringement on the third interest is the most serious form of prejudice, because the inability of the defendant to adequately prepare for his or her case skews the fairness of the entire system. The nature and extent of the prejudice arising out of a delay bringing a criminal action to trial is the most important of the Barker factors. Here, a 90-day delay in proceeding to trial from October to January does expand defendant's pretrial incarceration. This factor weighs against finding good cause. The second factor to minimize anxiety and concern has not been argued by the defendant. To the contrary, her counsel, while acknowledging her mental state is fragile and complex, states she has been able to cautiously and rationally cooperate with the preparation of her defense. This factor is neutral in this assessment. The third factor, to limit impairment of the defense, weighs in favor of finding good cause. Defendant's counsel has voiced their diligence in preparing her case. However, relatively recent appointment of her lead counsel and the even more recent appointment of her co-counsel in light of the severity of the crimes charged and the voluminous discovery leads the court to find that continuing the trial would not result in any impairment to the defendant's defense of the case. The resulting delay, if the state's motion is granted, would afford defense counsel additional time to prepare for the trial. On May 2nd, 2022, the state filed notice of intent to seek the death penalty against the defendant, Lori Daybell. This inarguably complicates the preparation of a defense. Of note, no argument has been advanced by the defense that the delay would impair their ability to defend this case. On balance, this factor weights in favor of the state's request. So there's 2 against the state and 1 for the state right now. In weighing the Barker factors, the court considers that those factors weigh in favor of granting the state's motion. In addition to those factors, the court must determine pursuant to, so there's 2 that squashes the right to move her trial and 1 that supports it. So it should be squashed and she should have her trial. If you go by what they just said here, there's 2 in favor of her trial going forward in October and 1 going in favor of moving it. So by right, even by what they said here, it should be squashed and her trial should go ahead. But in addition to these factors, the court must determine, pursuant to State versus Clark, whether there is substantial reason that rises to the level of legal excuse for the delay. In this case, the defendant is charged with a co-conspirator with Daybell. The overt acts alleged in the indictment and the conspiracy charges have led this court to conclude that the defendant and Daybell should be tried together in a single trial. The court is cognizant that the defendant is in custody and has been in custody for an extended period of time. While that factor weighs heavily and undue incarceration before trial must be limited, it does not outweigh the factors favoring a finding of good cause. Wow. In summary, this is a death penalty case. The discovery of volume is extraordinary. The defendant's defense team has only recently been fully assembled and has expressed concerns with the ability to fully prepare to defend their client in October. The trial itself has been set for a duration of 10 weeks, which further confirms the scope of the evidence the state intends to introduce. The court is concerned that the defense may be impaired by being required to commence trial in October, where they are relatively recently appointed to the case. On the other hand, the state has had far more time to prepare its case, nearly 3 years since the defendant was initially charged in the first case. That's with not producing the kids. Defendant has advanced no argument that the delay sought by the state would impair her defense of the case. Finally, the court has previously determined that her case is to be tried together with Daybell in a single trial, and advancing Daybell's trial to October may prejudice his defense. So they're worried about prejudicing Chad, but not Lori. Lori has a right to a speedy trial. Chad waived his right to a speedy trial. So they don't want to prejudice Chad, but they'll prejudice Lori. Like, both of them should get the death penalty, but you still got to protect yourself. So if she appeals this because her rights were violated, she's going to walk. On balance of all these factors and in full consideration of the record before the court, it is determined that the state has met its burden demonstrating substantial and competent evidence that good cause exists, requiring this court to extend the 6-month time for trial as prescribed by statute. Oh my gosh. Further, this court determines, based on the same rationale, the defendant's concurrent constitutional rights are not violated by extending the time of her trial by additional 82 days. Yes, she did, because she refused again last week to waive her right to a speedy trial. It doesn't matter what her attorneys say. They have to go by what she wants. She wants a speedy trial, and they have just thrown that out the window. So no matter what your lawyer says, your lawyers have to go by what you want. She wants her speedy trial. Do I think she should wait? Absolutely, but she didn't, and that's what they have to go by. She doesn't work for her lawyers. Her lawyers work for her. And if she has said, I do not want to waive my right, they cannot do that, and they cannot try and lean the court to do that in the direction that they just did. So accordingly, the court will grant the state's motion to continue the defendant's trial from October 11th to January. It's so ordered. So there you go. I think that what the court just did, is set Lori up to walk on appeal. That's what they just did. So Lori's case is not going to happen now in October. It's going to happen with Chad's. So let me get this in my book. I just got to write this down so I don't forget. And like I said, you guys, you have a right, and she has a double right, because not only does she have a constitutional right, she also has a statute right in the state of Idaho that gives her even more protection for a speedy trial. Now, when you tell your lawyers, I don't give a crap if you got to work day or night, I want my speedy trial, she is entitled to that. The only reasons that the prosecution has given is, well, it gives her lawyers more time, and we don't have to try it twice. We don't have to pay for 2 trials, and that gives us time to get more of our DNA evidence back. That's not the defendant's problem. What the problem is here is you just took away her right to a speedy trial. She doesn't just have that under the Constitution. She has that under statutes of Idaho, which gives her double protection for a speedy trial. She's going to appeal this, you guys, and she's going to walk. She's going to walk. Take me as saying it. Final answer. She's going to walk on appeal. You cannot take away a person's right to a speedy trial to appease the prosecution in, oh, well, we don't have all our evidence back. You've had 3 years, 2 years since the Chad was indicted on all these charges. You couldn't indict Lori, although the indictment was sitting there waiting, because she had already been sent off to a mental hospital on the previous charges that she was facing with not producing the kids. Competency was erased there. You cannot blame the defendant for being incompetent, and you can't bring her to arraigner, because the indictment came down after the other charges when she was being sent away. So they can't blame her. You cannot use somebody's mental health issues or being sent away for an evaluation against them, especially when it happens before you can even arraign them on the charges. The charges were sitting there waiting for her to be arraigned on, but those charges only came to the court after she was found that she had to go to the mental hospital on the other charges. Lori's going to get what's coming to her on the other side. That's where it's going to, because I'm telling you right now, that is my final answer. They have now taken her rights away from her, whether her lawyers want it or not. She doesn't work for the lawyers. The lawyers work for her. So just even up to last week, she's saying, I'm not waiving my right to speedy trial. I want my trial and I want it to go ahead. And this could send her back into incompetency again because they're taking away her rights. And I do believe that they will be found guilty. But she, on her appeal, every death case, every death penalty case is automatic appeal. It's automatically appealed. Like they have to file their paperwork. The defense has to file their paperwork for it if they're found guilty. But every death penalty case that I've heard of always goes to appeal. They will find something to appeal the verdict on. But on Lori's appeal, she doesn't have just nitpicking within the trial. She has my rights to a speedy trial were violated. And I believe that she will walk. Sorry, but that's what I believe. You cannot have a blatant disregard for somebody's constitutional and statute in your state rights. It's not the defense's problem that the prosecution doesn't have their DNA back yet. Chad is going to be gone. Chad's gone. Lori, I believe, will walk on appeal. I think he's going to be found. They're both going to be found guilty, I believe. I do believe that. But what I'm saying is she's going to appeal this and she may walk. Her constitutional rights and her statutory rights have been taken away. I don't think she'll be back in the nut house before she can file her appeal and try and walk. And I believe that she may walk on these charges because they took away her constitutional rights. Even her defense said, you know, if you guys feel that you have enough evidence to move it or enough cause, just cause to move it, the just cause that they stated was, and you can't find just cause for the defense. You have to find just cause in the prosecution. The prosecution said, well, it's going to cost us double the money to have 2 trials. It's going to cost us have to do the same evidence twice. They were charged together, so they should be tried together. And we don't have all our evidence back yet. No, absolutely, absolutely not. That is not just cause. They've had 2 years to get their crap together. Lori is entitled to her speedy trial, which up until her last hearing last week, she still refuses to waive it. Even her defense said, Of course, we would love to have more time if there's just cause, which to me, there's not. There's just excuses because it's going to cost prosecution more money and they have to try the case twice. And they don't have their evidence back. That's not justifying moving her trial. And her lawyer said, we would have to work like day and night, but we will be ready if so happens to go on October 11th. So with that being said, and that's all on record, I'm telling you, you guys, she could walk on appeal. She has a very good chance of walking on appeal because her rights were violated. 6 months starts from the time of arraignment, not from the time the indictment gets to the courthouse and is filed. You have to arraign somebody. You have to have them in custody and arraign them. Some indictments come to the court and are sitting there for 8 months because they have to find the person and arrest them to bring them before the judge to be arraigned. That doesn't mean that their speedy trial rights, they don't get them now because they haven't been able to find the person. No, your speedy trial rights start from the time you are arraigned. Well, Chad's lawyer really doesn't give a crap because he wants them severed anyway. So we're going to have to wait and see how this plays out, you guys, but I'm very concerned, and I do believe that Lori could walk on appeal. If she appeals this decision, I believe that they have taken away her right to a speedy trial. She has demanded it. She has told her lawyers, get ready for it because I'm going in October. I'm not waiving my right. And that was just taken away. And I don't find that there was just cause. You can't use, as a prosecutor, when an indictment comes across your desk, you better have all your ducks in a row before you arrest that person and have all your evidence and be ready to go. Look what happened in the Barry Morphew trial. You best, when you arrest that person and bring them in front of the judge for arraignment, you best make sure that you are ready to go. So I'm telling you, I think she's going to walk on appeal. We'll have to wait and see, but as it stands now, they have moved her trial to January, and they're going to be trying these trials together in Ada County. And there's a change of venue and all that crap that goes with it. Yeah, Marie, as far as I was concerned, they had two choices. To keep Lori from walking on appeal, they had two choices. They try their cases separate, or they move Chad's to October because he waived his right to a speedy trial. He waived his rights. So why wouldn't you move Chad's trial? Sorry about your luck, bud. You waived your rights. We're moving your trial again. Instead of taking away somebody's rights who's made it quite clear that she wants her speedy trial. And even her lawyers, are they going to fight about having more extra time? No, they don't mind having the extra time. But they said if she is, which she is doing, she is refusing to waive her right to a speedy trial. They said that they will work day and night to be ready to go. So the prosecution using, oh, well, the defense really isn't ready enough yet and only been recently appointed. They can't use that as an excuse to extend the trial. They have to have reasons on the prosecution side, not the defense side. Diane, if her rights have been violated to a speedy trial, I'm telling you right now, she will walk. If on appeal, they find that her speedy trial rights were denied and taken from her, you're damn right she's walking. They even stated it in this document I just read. Go back and read it. That they run the risk of her case being dismissed, her walking. That's one thing that the judge had to take in consideration. And guess what? It's going to happen. And I do believe she can walk. on appeal. Yeah, I did believe I believed that the judge was going to move Chad to October because they've had almost 2 years to prepare. They should be ready to go right now. But don't forget, the prosecution still hasn't got all their DNA evidence in yet. It depends when the appeal happens, Weekend Widow. If she appeals it between now and January, okay, because now her court date has been taken away and her speedy trial rights have been taken away. If they appeal it right now and get their appeal in before the January 9th date, she could walk. Case dismissed. It said it right in the, and it said it in the documents. I've been saying this since last month when she was arraigned. And it was in the document. So we're going to see what happens. Are they going to, is Lori going to say, I want to appeal it right now? I don't know. Well, Mike Dempsey, that it could very well be because she's still facing charges in Arizona for the death of her husband at the time. I don't know if they were divorced at the time. I think they were. Charles Vallow. She's been charged in his murder also. So, I mean, it's not like she's going to walk out the door and be free. I'm sure right now Arizona is preparing to come and get her if she files an appeal. I do believe that they would be coming out and picking her up from Idaho and bringing her straight to Arizona to face the charges of first-degree murder with Charles Vallow's murder. Nana, it's not just the Social Security fraud. She has been charged with the death of Charles Vallow. She's being charged with his murder. So it's not just the bank fraud in Arizona. That is also the death of Charles Vallow. That's not on this indictment. That indictment is out of Arizona. That's okay, Rosie. Oh my gosh. I hope you don't, my dear. And if it does come back positive, pump yourself full of fluids, vitamin D. Vitamin D, girl. Vicks Vapor Rub all over your chest, nose, and vitamin D. Keep yourself hydrated. And hopefully you don't get the bad strain. Arizona's always a mess. Exactly. Including your own children. Oh no. Pump yourself, Rosie. Pump yourself. Vitamin D. Vitamin D. Double doses of vitamin D. And I'm telling you, plaster yourself with Vicks. I know somebody who had COVID, and that's what they did. Their chest, under their nose, and their back, Vicks. And under your feet, put a pair of socks on. Vicks. I don't know what it does to help kill the virus, but it does. Yeah, I haven't been feeling too well either, and I've been going out without a mask on. I hope to God I don't have it, but I don't have a test. So I might have somebody go and pick me up some tests. But it's just like the heaviness on the chest and stuff like that, the mucus. I don't think I have it, but if I do, I have the very mild strain. I don't know. I'm in Canada, Marie, so that's something I'd have to look into. Yeah, vitamin D, vitamin D, vitamin D3. That's what I'll show you right now. Vitamin D3, 1,000 milligrams twice a day. That's what got me through the hardest time. And I take the B12, 1,000 milligrams twice a day. And plaster myself with Vicks. Like I go out, like I gotta have a shower before I go out. Wash myself down before I go out. It's all in sinuses. Yep. Plaster the Vicks. I'm telling you, your chest, your back, and under your nose. Plaster the Vicks. Yeah, it's spreading. But I think it's a weaker strain, so I generally do wear my mask everywhere I go, but I didn't have my mask and I had no choice. Yeah, the Vicks, I'm telling you, the sinuses, it like even when I get really bad sinus infections, which I'm prone to, Vicks, 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 Vicks. Plaster yourself, like get yourself a couple big jars and plaster yourself. If you got a vaporizer, put it in your vaporizer too. Ah, okay, so there we go. Butterfly Dana, I did answer your comments. Girl, you're not blocked. Why would you be blocked? You are not blocked, or I wouldn't have been able to see that right there. I haven't heard of the ginseng yet, but I know the D3. Pump yourself D3. Get yourself a lounge chair. Put it out on your deck or something and lounge in the sun. D3, I'm telling you. Yes. No, you're not. This morning, Butterfly Dana, I was late because we had power outages and stuff, so I was late getting on. So I basically just sat there and tried to watch as much of it as I could. So we're going to have to wait and see. I'm going to be watching the record to see if Lori Vallow's attorneys file anything. I'm pretty much assuming that they're going to be. Yes, force fluids, like you got to stay hydrated. Oh, you guys are heading into winter. Okay, because we're just heading into summer. Get yourself a tanning lamp. Artificial sun. But pump yourself with D3, Rosie, I swear to God, and Vicks. B12 doesn't hurt either. Yeah, Vicks works really good. I've heard a lot of people who've had the COVID said the Vicks did wonders. Yeah, he looked like hell. Yeah, steam showers too. Oh, okay, they're not allowed there. Okay. Do you have heat lamps? Like a lot of people have heat lamps in their bathrooms. Oh, Vicky, girl, Vicky, we have to remove that because you said instead of Vic, you said add a D to it instead of a V. Let's remove that. Sorry, Vicky, I had to remove that. Hi, Rosie, I'll live. I'm a duffel bag. Oh, not in the new place? Okay. Yeah. We'll have to wait and see what happens with Barry. I think he's going to get a hefty fine. That's what I think is going to happen with him. I don't think he's going to get jail time. I think he's going to get a really stiff. And he has got Iris Eaton representing him on those charges too. And Barry Morphew is using Iris Eaton's address because he doesn't have a permanent address. So he's using Iris Eaton's. If you guys see me this morning, it's like, it's funny. The kiss on the lips that she gave to Barry after his case was dismissed, hugging both the girls, telling the girls that she loves them, and the girls saying, we love you too. Almost like, what? You don't even show that love and compassion for your own mother, but you're showing it for Iris. And then she kisses Barry on the lips. And I noticed she hasn't been wearing her wedding bands. So did Barry change girlfriends? Because we haven't heard of Shoshana. And Barry is using her address as his. I know you didn't, Vicky. I know you didn't. But I had to remove it. It's no problem, Vicky. Stars Bright. You're going to have to go back and watch the replay. We're just wrapping this up, and I'm about to get offline. So if you want to see it, you're going to have to go back. It'll be available in it should be available right away. Sometimes it takes 20 minutes for it to come back up. Maybe Barry and Iris are living together. Maybe. Who knows? Because we haven't heard of Shoshana, right? It was funny, but yeah, nope, can't leave that there. No, that's not a conflict of interest. If I got charged with something and I was married and my husband was a lawyer, or if I'm dating somebody who's a lawyer, that's not a conflict of interest. If I used him as a lawyer. I'm talking about this one here, Butterfly Dana. It's depending on how long they are. If it goes, sometimes it goes unavailable for about 20 minutes. I know the morning session is now available, so this one should be too, but you never know. He's back in court for the other charges. You're going to have to go back and watch it from the beginning, Stars Bright. Okay, so with that being said, you guys, thank you for spending some time with me again. And if anything else breaks, I will jump right back on here and bring it to you. But I've got dinner on the stove there I got to get back to now. So with that being said, you guys take care of yourselves. Stay safe. Thank you for my mods for jumping on. I appreciate each and every one of you. Love you guys all to the moon and back. Till next time, take care of yourself. Stay safe. Bye-bye for now.